Court calls the case People versus Jaden Marks.
Ready, Your Honor. Joseph, Your Honor. Your Honor, Joseph, on behalf of Mr. Marks, Jaden Marks.
All right, very good. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Plea form indicates that defendant would be pleading guilty to 2 charges. First charge is operating while visibly impaired. That's an added count 3, the 93-day misdemeanor, and also an added count 4 of transporting or possessing a firearm in a motor vehicle, the 90-day offense. In this case, there is also, and counts 1 and 2 would be dismissed. There's also a sentence agreement. I don't know what this is saying.
Your Honor, I apologize for my handwriting. It should indicate.
That's handwriting? No, go ahead.
It's my gun forfeiture, gun safety class, conditions for the court. People would not recommend upfront jail time as part of the sentence, and there is an agreement between the parties. That would be extended height as to count 4.
It's to count 4 only, yeah. Right. Okay. Good. May I have it for?
You solemnly swear to tell the testimony about guilty, the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Jaden Marks.
All right, sir, it is this court's understanding that you're going to plead guilty to 2 misdemeanor offenses. Is that your understanding?
Yes, Your Honor.
The first is the added count 3 of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes, sir.
The added count 4, transporting a firearm in a motor vehicle. That is also a misdemeanor punishable by up to 90 days in jail and a $100 fine plus court costs and mandatory forfeiture of the firearm and or device. You understand that?
Yes, sir.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes, sir.
To the charge of operating while visibly impaired, how do you plead? To the charge of transporting or possessing a firearm in a motor vehicle, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights? Please look at paragraph 5. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
November 24th, 2024, at the location of Washington Avenue and Grant Drive in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
The majority of a fight.
Were you stopped by the police or was there an accident?
Stop.
Why'd they stop you? All right. You're not disputing the right of the police to stop you in this case, are you? Were you ultimately arrested?
Yes.
Were you taken to the police station or hospital?
The hospital first, then
They did a blood draw?
Yes.
What were the results of the blood draw?
Points 149.
0.149.
Yes, sir.
Do you have any reason to dispute those blood test results? Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
All right. Did you have a firearm in the vehicle?
Yes.
Where was it located? Here's a bag where?
Oh, the passenger seat.
On the passenger seat?
Yes.
Okay. Was it loaded?
Yes.
All right. Do you have any authority to carry a firearm in that fashion?
At that time, he was pending approval for his CPL. He actually got it about a month later.
All right, but at that time, you did not have the authority to carry that. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, you have, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation is ordered. Sentencing in this matter will be April 30th, 2025. What time? 12 noon. Or as your invite indicates, and that's before me. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Patrick Conley.
Such a lot for the people.
Who?
Oh, so sorry. It's in front of me.
Yes, it is.
Apologies, Your Honor. At least I'm in the room. Assistant Public Defender Jay on behalf of Mr. Conley. Mr. Conley, taking it for the record again. Patrick Conley.
All right.
And Your Honor.
The court should be in receipt of plea form. Not yet. Okay, then yes, me to it. Correct.
All right, you guys are gonna have to get this plea form into us earlier. I don't.
I'm sorry, Your Honor. I always try to get them in earlier. I apologize. Your Honor, the defendant's going to be pleading to an act of count 5 of use of a controlled substance to it cocaine, and the currently charged count 2 operation of a motor vehicle without security. In exchange for the pleas to those 2 misdemeanors, count 1 possession of controlled substance to it cocaine, count 3, and count 4 will be dismissed.
Is that a correct statement, Mr. Bellender?
Yes, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Patrick Conley.
Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
Yes, sir, it is.
The first is that of use of a controlled substance, that being cocaine. That's a misdemeanor punishable by up to 1 year incarceration at $2,000 fine plus court cost. Do you understand that?
Yes, sir, I did.
It's also this court's understanding that you're going to be pleading guilty to the stated count 2 of operating a motor vehicle without security. That's a misdemeanor punishable by up to not more than 1 year in jail and not less than $200 nor more than $500 fine plus court costs. You understand that?
Yes, sir, I did.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in 14B District Court.
Yes, sir, I did.
Understanding all of that, you still wish to plead guilty.
Yes, sir, I did.
To the charge of use of a controlled substance, how do you plead?
Guilty.
To the charge of operating a motor vehicle without security, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form.
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty in this case, you'll be giving up, waiving or giving up those rights as well as all the rights contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Yes, sir.
Were you on probation or parole at the time of this offense?
No, sir.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
Doing this voluntarily
Yes, sir.
of your own free will?
Yes, sir.
And because you believe that you're guilty of these offenses?
Yes, sir.
January 12th, 2024, at the location of Evelyn Avenue, Hull Street, Ypsilanti Township, Washtenaw County, State of Michigan. Were you in possession of cocaine?
Yes, sir.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes, sir.
And were you at some point also at that location operating a motor vehicle?
Yes, sir.
Did you have proper security or insurance on that vehicle?
No, sir, I didn't.
All right, counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2 and 5. Counts 2 and 5. Counts 1, 3, and 4 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
April 17th at 10 a.m. before Judge Washington.
April 17, 2025, 10 a.m. before Judge Washington. Bond will continue. Thank you. Court calls the case of the People versus Alan Payne.
Rest of the people.
Your Honor, Joe Simon on behalf of the bank. You're up here. Elevate.
You're requesting an adjournment.
Yes, Your Honor.
How much time are you guys looking at?
The April 10 day would work if that fell.
Shouldn't have asked. April 10th, 2025, 9 a.m. I know you were surprised I even did.
Thank you, Your Honor.
Thank you. Yeah. They're not up over. They're not there. Court does call the case of People versus Kane Kellenberger.
Echelon of people.
Your Honor, Senator Bernstein with on behalf of Keith Helmberger.
Your name, sir?
Your Honor, hoping for adjournment.
Probable cause conference will be adjourned April 3rd, 2025, 9 a.m. Bond continued.
Thank you.
Court calls the case of the People versus Ashton Dew.
Echelon of the people.
Your Honor, Joe Simon on behalf of Mr. Dew, making his way to the court. Ashton Dew. Your Honor, I have one epilogue from the discussion I had with Your Honor with Lonnie yesterday, which is the probate attorney is going to make an amended order. Trying to see that. I offered the court suggestion and hopefully that will work out. So.
Okay. If from this court's perspective, if there's anything else that's needed, just get to us and we'll take care of it.
Thank you. We certainly appreciate Your Honor's effort.
All right. And how much time are we going to be looking
I
at?
should go that April 10th. I know, but you asked. That was what
Is this your last case?
it is.
Cool. Probable cause conference, April 10th, 2025, 9 a.m. Whereas your invite indicates bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Mr. Simon. Have a good day.
You too.
This is another one, which I believe is right there.
They have them.
Yes.
Court calls case People versus Nicholas Elka.
Good morning, Your Honor. Katie Wisniewski for the people.
Good morning, Your Honor. Senator Bernstein, with on behalf of Mr. Elka.
No, they don't. Hold on one moment. I don't know. I thought do they have it? Your name, sir? Thank you.
Your Honor, may we approach?
Fine.
I appreciate that. And this morning, Your Honor, after further investigation and time spent reviewing the file, it was the people's intention to dismiss the just proceed on count two spot.
Any objection?
No, Your Honor.
Count one is dismissed.
We're going to be waiving on count two.
All right. Sir, is that a correct statement? You're waiving your right to a preliminary examination on count two?
Yes, Your Honor.
All right. You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right. People also waive their right on that.
Me too, Your Honor.
All right. Preliminary examination having been waived as to count two, defendant is bound over on count two. Mr. Bernstein.
Your Honor, ask the court to please waive reading, enter not guilty plea, and I'm in some technically some information, but I will be.
All right. Defendant having waived formal reading, pleading not guilty, count two. Court will enter that plea. Pretrial will be set for April 1st, 2025, 1:30 Judge County.
Thank you, Your Honor.
Thank you, Your Honor. And as to the information, just to let the court know, we will have a new one prepared with just count two and that file.
All right, very good. Thank you.
Thank
The other thing that you can do, counsel, if you want, is you can strike count one from that one, initial it, and then sign off on the one that's in there. Either way you want to do it.
Thank you.
Court calls the case of the People versus Mark Pettis.
Good morning, Your Honor. Senior Representative Mr. Petty. Of course, block case. I'm asking for an adjournment to continue reviewing discovery and have a short line.
Probable cause conference, April 3rd, 2025, 9 a.m. Yes, that's fine.
Your Honor, Mr. Petty's is a commercial truck driver, and his position is a lot more lucrative. He's able to travel outside of the state. So I'm hoping the court would please consider him being able to travel outside of the state for employment purposes.
Any response from there?
Your Honor, is that the objection to any alteration in law? This is rather serious sexual contact. Is there a motion?
What states is he looking to travel to?
What states are you hoping to travel to?
Just regional in the area, probably Indiana, Chicago, Ohio. I don't know.
Is there a schedule of those trips? Is there a schedule?
No, not yet, not this moment. I can't get the actual job. So I know that's what you just say. Job dedicated was.
Motion for modification of bond is denied at this time.
We'll get some paperwork on motion.
All right. Thank you.
Thank you, Your Honor.
Court calls case People versus Chancel Bray Page.
Ready to go. Yeah, yeah. Same reading, Your Honor, retain counsel. Brett Page.
Your name, sir?
Johnson, Brett Page.
All right. All right, what are we doing?
Yeah, I was just recently retained on this matter. I'm gonna respectfully asking for an adjournment. So I can get this stuff.
All right, I'll grant the adjournment. All of your fellow counsel here, nobody told you about the green sheet you needed to fill out? Oh, no, that's not on you. There's all of these people over here that could have helped you out. Sissy Feaster, and he didn't help you out. That's okay, so I'm gonna talk, I'll deal with Feaster. It's not on you. How much time did you need?
I guess about 2 weeks.
All right, fantastic. Probable cause conference, April 3rd, 2025, 9 a.m. Bond in this matter will continue.
Thank you.
Thank you. And if you can just fill that out and get it to us, that'll work out. Court calls the case of the People versus Romerio Buckner.
Joseph, you don't have to be on?
Morning,
Judge, I was just appointed by this matter. Can you give me
Probable cause conference, April 3rd, 2025, 9 a.m. Bond continued. Court calls the cases of the People versus Taiwan Browning. 4 cases.
Good morning, man. Please don't report. Kareem Johnson, that's all for case job.
Your name, sir?
Taiwan Brown.
All right, what are we doing?
Yeah, this time I'd like to set the matter for.
All discovery is complete.
Yes, no, that's to all cases.
People have their witnesses available on these cases April 1st.
I will make sure that I set up most of the police officers, so I don't get a problem.
Preliminary examination, April 1st, 2025, 9 a.m. before Judge Perry.
Yes.
Did you say April 1st?
Yes,
Okay.
before Judge Perry. Bond will continue. Thank you. Court calls the case of the People versus Kyle Burmeister.
James Badowski, appearing on behalf of Councilor State Police Sir Kyle Brian Burns. Your Honor, we are requesting an adjournment to possibly resolve this case along with his other pending misdemeanor case, Ms. Londi has. So I'd be asking for a 2-week adjournment, and then I can address the bond issue.
You need to address the bond issue before I'm going to give you an adjournment.
Your Honor, my client tells me he never had noticed that he had to go to community corrections on this case. And I am looking at the court activity from this file, from the arraignment that he was given. It only indicates bond amount 5,000, personal cognizance. There's nothing listed in the conditions section. I went through all this paperwork and said he's kept everything.
Except he was advised on the record that he would be subject to drug testing on that same day by Magistrate Odutella, and I have that form. So I'll match my form against yours anytime.
Well, all I can add, Your Honor, is that he actually had.
Why didn't he go?
Inpatient treatment.
Did he go over?
He tells me he didn't either recall or didn't have anything to explain. I think once he was released from jail. Any paperwork that said I had to go. And so maybe with the confusion of these cases, the good thing though, Your Honor, is I have verification. He went to the JIRA residential from February 25th, and he completed that actually early on March 7th. He can test today. He's telling me he should be fine. He is not in.
I'll pass it. He needs to get over there and test now.
Thank you.
Court calls case People versus Maurice Anthony. Can you let him know he's been?
Gotta release these 3 matters, Jonathan, make that.
This is public defender, Kelsey Reveal, on behalf of Maurice Anthony. Is there anything?
Go ahead, counsel.
Your Honor, Mr. Anthony would like to waive his right to a preliminary exam in all 3 cases.
In all 3. Is that a correct statement, sir? You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have hearings in any of these matters, and you'll proceed to circuit court for further resolution. People also waive their right in these cases. Preliminary examination having been waived, defendant is bound over to circuit court on the 2 counts contained in the case ending in 600 and 1 count in each of them. Go ahead, counsel.
Your Honor, we would acknowledge receipt of the information, waive its formal reading, and stand U.S. to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all charges. Pre-trial in these matters will be set for April 2nd, 2025, 1:30 before Judge Conlon. Bond will continue in these cases. Court does call the case of the People versus Brendan Chrysler.
Ready, Your Honor. Myself, Chrysler. Your Honor, Mr. Chrysler had a medical situation and currently is at Quality Behavioral Health, which is a residential program. I have a letter verifying this. I spoke to their staff this morning. Essentially detox rehab. So he's not able to be here. I've shown this to Ms. Londi. My request in any event, because I'm new to this file, is for an adjournment. Court can put it out a couple of
People have,
No, Your Honor, I have been to be in detox. I didn't realize it was, it's fine, that's fine. Perfect. Sounds great.
April 3rd, 2025, 9 a.m. Bond continue.
Thank you very much.
Court calls case People versus Daryl Hick.
Morning, I understand first name, but not happy.
Sir, your name? Thank you.
In this case, we've been awaiting further discovery, specifically CT scans and MRIs. I did just receive a supplemental report that what I've been asking for has been in his possession. The sheriff department's at 214, so hopefully that gets to me right away and get this moving.
That's not.
Okay, got it. So how much time? Pardon?
Hoping for an adjournment to accomplish that.
Will 2 weeks be enough to get
Yeah,
that?
sure. I thought that the CT scans were sent out to council, but.
They were.
haven't, so
Gotcha.
I think-
April 3rd, 2025, 9 a.m. bound considered. Calls the case of the people versus Lawrence Buckner.
And it's on behalf of the people, Your Honor.
Good, I think the people stated their appearance.
Assistant Public Defender, tonight carry I can move Your Honor on behalf of Mr. Lawrence Faulkner, and it's 1106.
Want to be pleased honorable court, Ray Johnson, on behalf of this collector of medication.
All right, what are we doing?
And we respectfully request that I think both matters be set for preliminary examination.
People have their witnesses available the first.
We'll do our best, Your Honor.
Preliminary examination on these matters will be set in person April 1st, 2025, 9 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Johnny Bankhead Williams.
And it's on behalf of the people, Your Honor.
Stephanie Cannon with the Public Defender's Office, with on behalf of Mr. Bankhead Williams, who is appearing to my right. Mr. Bankhead, could you please state your name for the record?
Thank you.
Thank you.
Your Honor, at this time, my client would ask for his preliminary exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the first.
We'll do our best, Your Honor.
Preliminary examination in person, April 1st, 2025, 9 a.m. That is before Judge Harry. Bond continue. Thank you.
Thank you, Your Honor.
Court calls case of the People versus Trayvon Addison. Go ahead. Okay, go ahead. I'll let you go. Happy birthday. Huh? Well, yeah, everybody told me it's like a big festival out there.
Yeah.
All right.
Just requesting an adjournment of a couple weeks. Mr. Jackson would like to review recovery, family, and discuss his options.
All right. Your name, sir?
My name is Trayvon.
Thank you. Probable cause conference will be adjourned April 3rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
I think she would freak out if I had the court sing to her. She'd probably follow. Court does call the case. People versus Robert Lewis. Pardon?
The waiver of exam.
Okay, he's waving. Okay.
I have you call it first or then? Or just have you sign it now?
Oh, well, I called the case,
Okay, good.
so I just need appearances,
Oh, good.
and then you guys can sign the form, and I'll question it.
I was waiting for the prosecutor, but maybe they did say something.
Again,
Wendy Barnwell, P42505, on behalf of Mr. Robert Lewis.
sir, your name?
Robert James Lewis.
All right. He needs to sign that examination waiver. You're waiving your right to a preliminary examination, sir?
Yes, Your Honor,
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count. Counsel?
We waive a reading of the information and standing.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for April 2nd, 2025, 1:30 before Judge Conley. Thank you. Bond continues. Court calls the case of the people versus Cameron Brown.
Joseph and all that people, Your Honor.
Stephanie Cannon on behalf of Mr. Brown. We have Mr. Brown, who is appearing to my right. Mr. Brown, could you please state your name for the record?
Thank you.
Your Honor, Mr. Brown is electing to waive over to circuit court.
Is that a correct statement, sir? Okay. Is that correct that you're waiving your right to a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing, you'll proceed to circuit court for further resolution. People also waive their right.
Yes, we do, Your Honor.
Preliminary examination having been waived, defendants bound over circuit court on both counts.
Your Honor, we would waive for a reading of the information and the charges.
Defendant having waived formal reading, standing mute, both counts, court will enter a not guilty plea. Pretrial will be set for May 12th, 2025, 1:30 before Judge Hammoud.
Thank you, Your Honor.
Thank you. Bond continues. Court calls case of the people versus, is it Kieran Cheeks?
And then on behalf of the people, Your Honor.
Brian Boyd, on behalf of Mr. Cheeks.
And Your Honor, at this time, people are unable to proceed as to count one, would ask that count two be remanded to district court.
No objection to that, Your Honor. I'd like to address bond.
Count one is dismissed. It's remand for pretrial. Count two, that is before judge. We have a pretrial there.
Yeah. April 16th at 9 a.m.
April 16th, 2025, 9 a.m. As to bond.
Thank you, Judge. Mr. Cheeks is being held on this matter alone, $1,000 10% bond. He and I discussed yesterday about other terms and conditions related to bond, which he would follow, abide by, specifically no contact order and any no vote order that was set as arraignment. He did indicate to me he has other possible residents in the city of Detroit with his sister and her children. He also has a job waiting for him when he gets out of custody. Now that the felony has been dismissed, the pending misdemeanor being remanded to the district court, I'd ask the court to consider releasing Mr. Cheeks.
Response.
Your Honor, I'll leave it in the discretion for, this court's familiar with this defendant, as he has another misdemeanor DV case, Your Honor. I'll leave it to the discretion, but I'd ask that no contact orders and no vote to be placed on the tether.
All right. I think Mr. Cheeks knows what will happen if I find out he didn't appear. So I'm going to release him on a PR, $5,000 personal recognizance bond. But he'll have to have a GPS tether prior to release with location tracking. All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case people versus Larry Clifton.
Your Honor, Lord Advocate Assistant Public Defender, was on behalf of Mr. Clifton, to stand to my right. Mr. Clifton, can you state your name for the court? Your Honor, the people have not made any offer. At this time, I do believe discovery is complete, so we would be asking that this case be separate.
All right. Do you want to say anything in terms of his bond? Because it's been denied, and my intent would be to revoke his bond at this point.
So, Your Honor, I do want to address bond. Obviously, the court is aware of the bond violation report.
I am.
Mr. Clifton acknowledges that he really truly made a mistake. I do want to highlight that there's no excuse, and Mr. Clifton doesn't attempt to make any excuses for the court for disobeying the court order. What I do want to highlight, though, is Mr. Clifton, the bond violation report indicates that the complaining witness did not indicate any safety concerns. I do think this is a situation where my understanding is she reached out to him. Again, that doesn't excuse Mr. Clifton himself from obeying the court order, disobeying the court order. He does have a lot of concerns right now about his daughter. He told me he's supposed to be having sole custody of her, and there was someone, or seeking sole. No, you do have. Okay. Yeah. Okay. And he has concerns about unauthorized people like picking her up from school and her whereabouts. That's been on his mind since his incarceration. He's been incarcerated. Yeah, so apparently an officer came to his cell and indicated that family members were concerned about his daughter, and he wanted to keep him updated. Mr. Clifton does have family. Yeah, and Mr. Clifton does have family support in the courtroom right now. So Pastor Alex is here and I had a conversation with him before court. He's willing to represent to the court that he will be a support for Mr. Clifton upon his release. Mr. Clifton knows that if he is able to get a bond, if he's able to post that bond, if he's released, he absolutely under no circumstances can have any contact with her or go back to the residence. He does have family he can stay with. And he
You didn't understand that before?
I'm sorry.
He said he didn't understand that before. And to be honest, Your Honor, it seems like he didn't, because clearly, right? However, he has been in jail for 9 days at this point, and he has done a lot of reflection. And And he just wanted me to let the court know that he understands why he's been in jail for the violation. And he does take responsibility, but at this point, we would ask if the court would consider granting him a bond. He doesn't have a source of income. His only source of income is, I believe, benefits. And so he really wouldn't have much ability to post a cash bond anyways, but he does have some family support. He potentially could contact. But that would be our request at this time, would be some sort of bond that he may be able to post until the next date.
Response from the people.
Thank you, Your Honor. We will be objecting to any modification of bond. In this case, the defendant's behavior had been escalating. The victim was they were having an argument. She was trying to create distance between her and him. So she threw his phone, tried to get him to get away from her. She tried to leave. He followed her, then grabbed her by her hoodie and forced her to the ground, and then got on top of her, put his hands on her neck and chest. She tried to fight him to get him off of her. He then strangled her, and she began to see stars. And while he was strangling her, he says, "You bitch, if you get between me finding my daughter, I'll kill you." Then not only after that, while he's out on tether, he doesn't just merely go into the exclusive zone, he goes right to her apartment building and is found at her apartment. So I have extreme concerns that he cannot follow court order to go on. So we would object to any modification of this bond, Your Honor.
Anything else?
The only issue I didn't mention before is I'm not sure if the people have, clearly the police have had contact with her since, because they spoke with her when they arrested Mr. Clifton. So I'm not sure what, kind of.
What was it about the condition he didn't understand and thought he could just disobey?
I really can't answer that. I think the only thing that
What, are you saying so far as him walking back into the red zone, back into the
I
apartment?
think he made a decision without thinking, Your Honor. I think he just didn't think that, didn't think about the consequences because I asked him.
What was gonna go to until Friday. And they told me that it was, so when they came and they told me it was a violation, I talked to the officers, over it, they brought me back. When I seen the judge told me the recommendation that you sent over to him. He read the recommendation that you gave him. He didn't argue against your recommendation. They sat me down, they explained to me what was going on, what happened. I told them I didn't clearly understand everything, but I do not. And upon that, she told me it was gonna be some questions of the concerns of the violation and that it could possibly affect my bond. I went over with them that we no longer have that problem. I'm grown, I got some support, and that address and that woman is no longer concerned of mine.
See, that's part of the problem. I'm ready to rule.
I'm only trying to tell him.
One thing that really stood out to me in my conversation with Mr. Clifton is he told me he felt like he was a first grader in 12th grade with all of this stuff. And we all know his mental health issues. It's right there in the initial police report that he was having mental health episode. That is in the 911 call initially. I think he does struggle. And I met with him for over an hour and a half yesterday trying to explain to him the legal process. I do think he struggles a bit. I don't think it's an excuse, but I just want to highlight that for the board.
I can't even think of a way that I would release him with any assurance for the safety of the victim. So I'm not going to do that. His bond will continue as revoked. You can make the argument after the April 1st, 2025, 9 a.m. preliminary examination before Judge Washington. So she can hear the testimony and then you can raise it at that point. Yes. Thank you.
Thank you.
Court calls the case, People versus Christian Leo.
And good morning, Your Honor. For the record, Brian Stacy on behalf of Christian Leo. Christian, state your name.
Christian John Leo, Your Honor.
Thank you. What are we doing?
Judge, at this time, Mr. Leo is being held in Oakland County. He was on a case on probation there, and this case in Washtenaw County violated his probation. They arrested him a couple weeks ago now. I have a bond hearing set for the next Wednesday, the 26th. I haven't had a chance to go over the discovery with my client. I'm hoping I can get him out on that date or immediately afterwards after he posts the bond. And I would ask the court to adjourn this matter to April 10th or April 24th, if that's convenient for Your Honor.
Any objection from the people?
No, Your Honor.
Probable cause conference, April 10th, 2025, 9 a.m. Bound continued.
Thank you very much, Judge. Always a pleasure.
Thank you. Yes, sir. Take care.
Blessed day.
Court calls the case, People versus Jeffrey McCullough.
People.
Good morning, again, Lori Gaggy, Assistant Public Defender with and on behalf of Mr. McCullough. Mr. McCullough, could you state your name for the court?
Jeff.
All right.
So, Your Honor, we're in a position now where Mr. McCullough is currently in the Dog Farms in Jail program. I believe he has 2 weeks left to complete it. So I believe his defense counsel, as well as the people, thinks it would be helpful and productive for him to complete it before discussing a potential resolution. So we would ask to adjourn in 2 weeks. I would also ask to address bond if the court would consider it.
If it's brief.
Mr. McCullough is held on another case. However, initially he was given a personal bond in this case. I asked that the court increase it because I wanted him to be earning credit in this case. He wants me to now ask if the court will lower it from the 5,000, 10%.
Is he held on another case?
I could potentially be released in 2 weeks.
So, Mr. McCullough is potentially looking at releasing his other case in 2 weeks, so he wanted me to.
When is that set?
It's not set, Your Honor. It would be a motion for release. So my understanding is he would have to file the motion. with-
More often than not, it's gonna be granted, Your Honor.
Why is he yelling at me? Anything you want to say?
I would concur in that motion. He's looking for the bond to be lower, Judge, so that it's reasonable enough that when he's released from the Dawn Farms program, he can post it. Right now, where the bond is set. Once he completes the Dawn Farms program, he will not be in a financial position to post the $500 on each case. I believe is what both bonds are currently set at. So by reducing it to say $100 a piece, once he completes his Dawn Farms program and takes necessary steps, then he can turn around and post the $100 or whatever.
But the other case he's held on.
Yes, Your Honor.
And the other issue is that I think he's been, so how long has he been in custody since January?
Yes.
January 26th. So he's been in custody a significant amount of time. He does have a couple more weeks. He's seeing some daylight, Judge. He's just looking to position himself, once he's done the right thing, to be able to have it him on that post bond.
Right, but that release on the other case is an automatic. Somebody's gonna have to file a motion.
Well, it's gonna be submitted to the judge.
You know what?
That's
You
correct.
know what? He's got two lawyers up here and he's gonna sit up there and just start screaming
You're correct, Judge. That's not
about the two lawyers and him screaming,
That's
or what?
correct, too.
Okay, thank you.
Well, what we're just looking, what he's looking, you understand, Judge.
I get it. Any response from the people?
Your Honor, I think that, since the legal program is still in the future, if something should change, council can provide that to the court, at that time, he would refer to the court at this point. So I would be, it's for the very 2025 matter. If that was complicated at that time, I think being done on its infection.
Right. Briefly address it. I don't have an intoxication case, and I don't think my co-counsel has an intoxication case.
Saying about the description of the work for the 2025 matter, is that part of that application?
Okay. So here's what I'm gonna do. What I'm gonna do is I'm gonna deny the request, and he's coming back in 2 weeks. So if at that time we need to address his bond at that point, I'm not gonna have a problem doing that. And in the interim, you can talk to him about how you don't want to yell at the court.
Yes, Your Honor.
Probable cause conference, April 3rd, 2025, 9 a.m. Something Bellinger had to learn too. He came to this county, he started yelling at me. We got that straight. Court calls the case, People versus Brandon Carter.
Assistant Public Defender Hannah Apple hearing on behalf of Mr. Carter. He appearing via Zoom
From where?
From Wayne County.
Jail?
No, Judge, I spoke with your staff this morning. I did submit a Zoom request. He told me he was on Zoom.
He did?
Sent a message that he was waiting.
You
Yes,
have?
I'm here, but it's not letting me actually show my face, though. Can you guys hear me?
And so, Judge, I didn't submit a Zoom request because he had active warrants.
Yeah.
I'm here.
Which hold on, Mr. Carter. I've been in contact with Mr. Carter since his release. On the date that the warrant issued, he was in Wayne County Jail. He was transferred from Washtenaw County to Wayne County to Macomb County, back to Wayne County. He's been on a tether for both Wayne County and Washtenaw County until Wayne County cut off his Washtenaw County tether while he was in their custody, and then I supposedly emailed back. I didn't submit the Zoom request because of the warrants, but then he had no transportation. He's been working for the last 48 hours to get that. So that's the reason he is out of Zoom, and I understand the court didn't give permission today, but I wanted to know that.
But you didn't care. Oh, well, that was kind of equivocal. You can't leave room with her. Oh, there he is.
Yes.
So what do you want me to do, Ms. Apple?
I'm asking for an adjournment now that he's out of custody from all of these other jurisdictions, so we can review discovery. I've been in contact with Mr. Carter, getting some potential mitigation.
I'm not lifting the warrant,
Okay.
so I'll give you an adjourn date. Well,
Okay.
1 or 2 weeks.
Mr. Carter, do you think you can have transportation next Thursday, or do you need 2 weeks?
2 weeks to be fine, because I'm moving out there. I'm going to a placement home out there for all my psych stuff going on. So I'm coming out there. So 2 weeks is
April
fine.
3rd, 2025,
Thank
9
you.
a.m. in person.
Yes, sir.
Don't thank me, thank Emily.
Thank you, Miss Emily. Bye, you guys.
Wow. I know you don't get that much, do you? Because it's all your fault. Court calls the case, People versus Michael Collison.
Do you just say?
Yeah, Michael Scott Allison.
All right. I wasn't really serious. Go ahead.
So we are just requesting a 2-week adjournment.
Really, all that for that?
Yeah, we're discussing a potential for a misdemeanor resolution, and I had spoke to Ms. Blondie this morning, who was just updating Mr. Collinson about that. He would also like me to respond at this time, if Your Honor will.
April 3rd, 2025, 9 a.m. As to bond.
Your Honor,
Judge Simpson, may I address you personally about that? Please.
No, you can, but usually when people have attorneys, they don't do that because it doesn't really work out real well. But go ahead, say what you got to say.
I just never got to talk to my attorney before this. Your Honor, on July 31st, you gave me a chance. You put me on probation.
Oh, I remember.
And you told me never to give up. Ever since then, I have been compliant with probation. I have been part of the Pathways of Recovery program. I'm very involved in the recovery program out here. I'm actually from Wayne County, but since probation, I've been out here. I'm in recovery every day, and the $100 bond is just something I wasn't able to get out of the Western Union with my lockup, and I would really benefit from a personal bond. I never got to talk to my.
Your Honor, I will just say, Mr. Collinson has bond set at $1,000, 10% on this case, and $100 on his other Washington County case. He does have a couple of holds on him. I'm not sure if they're holds that would result in him actually being kicked out. I believe some of them may just be traffic related. But if Your Honor would consider maybe lowering the bond to $100, 10%, just so it's something that he could afford to post. And if
The other one was $100 personal bond. Yeah, it was a personal bond.
Your Honor, you consider amending the bond to a lower amount or granting Mr. Collinson a personal 5% bond.
Response.
So it does appear that in October of 2023, the defendant had been charged with possession of methamphetamine, and we allowed him plea to use. think that's the case he's referring to that he was put on probation for. In this matter, police had contact with him on March 8th, 2025. He was found to be, I believe, in possession or to have illegally used someone else's credit card. A substance was found on him, and we just got the lab report back that came positive for match. And he gave a fake name to the police officers. So I actually think the bond is extremely low. We originally asked for a $25,000 surety bond, and I think he has 5 holds. So I frankly think the bond has been set extremely favorable to the defendant.
And Your Honor, I do agree that he does have 5.
He has 5 holds.
5.
Oh,
Yes.
5,
Again.
like
several
crab
different-
5
Right, exactly like that. Yes.
or Michigan seating.
Exactly.
Okay,
Yes, Your Honor.
okay.
That's fine.
Several different- And
Yeah, the name he gave when he had contact with Officer Stinky from Ann Arbor, I believe it was Jacob Collins.
Motion for bond reduction is denied. Bond will continue. Thank you.
thank you.
Court calls the case People versus Antoine Coleman. Hey, do me a favor. Go over and shake Kennedy and ask him why he's wearing gold. Just ask him. No weapon is immediately needed.
Mr. Cole, the Cole, please say your name for the record.
That's why we told.
All right, what are we doing then, Mr.
Not
Speaker?
gonna have to judge.
What'd you say?
Not gonna have to judge. Mr. Edwards and I decided to discuss potential resolution for this matter. I'm asking for a little more time so we can come up with something for Mr. Coleman.
All right. How much more time did you guys think you needed? 2 weeks. Probable cause conference without objection, April 3rd, 2025, 9 a.m. Bond continues. Thank you. What do you say? What? What?
I want you to know in my bracket, I have Maryland going.
Your bracket.
In my.
Oh,
I
on
have
yours?
Maryland going to the Big Ten. Oh, wait, it's the Elite Eight. The Big Ten is the thing that Michigan won.
You still got cases. You keep it up.
I'll be here all day.
Yeah, but it depends on in the courtroom or in custody. I don't know. All right, thanks. Court calls the case, People versus Devin Gother. See, he took it too far. It's gonna be a bad day for Kennedy. Bad day. Bad day.
Maybe I should have done spot. They're gonna act on behalf of Mr. Baldwin. Let me take his record.
Thank you.
Your Honor, we're asking for an adjournment. There's some additional discovery that we're waiting on. We could have 2 weeks.
2 weeks.
Yes, please.
Probable cause, like I care. Probable cause conference. April 3rd, 2025, 9 a.m. Kennedy, you should have never started with me. It's not gonna be good.
Thank you.
Thank you, Bonnie, too.
Thank you.
Court calls the case, People versus Jesse Crampton.
Brian Mulligan, Mr. Crampton, Your Honor. Your Honor, for purposes of discretion, the reason Mr. Crampton is not here is on that green piece of paper, and I didn't want to put it on the record, which I think you'll understand if you read it.
Got
To Mr. Bengalil about this case, based on the reason on the record. I would ask for it.
Under the circumstances, people have no.
You said that's the shortest amount of time. When you put at least, it's gonna be.
Yes.
Got it.
Yeah.
That's fine. All right. Probable cause conference will be adjourned May 22nd, 2025, 9 a.m. Thank you. Court calls case of the people versus Fleming Davis.
Doesn't all that people.
Mr. Davis, could you just say your full name?
David.
Lord.
Your Honor, we are asking for a 3-week adjournment to continue negotiations with the people. And I have also made a referral to our social work division for this review.
Probable cause conference will be adjourned April 10th, 2025, 9 a.m. Bond continued. Thank you, sir. Court calls case people versus Jacob Dorston.
Yeah, Jonathan, that people.
Assistant Public Defender, Councilor Gill, on behalf of the state of Dorston. Mr. Dorston, please state your name.
Jacob John Dorson.
All right.
We're asking for an adjournment if possible. We would consider the April 3rd date. Mr. Dorston has other cases potentially being resolved on that date.
They'll be resolved before that date or on that date?
His court date for those cases is on the same date.
Okay. Where? I'm just trying to, I don't mind giving it a third. I just don't know if.
15th, I believe.
Well, if you think they can get him those various places and it can be resolved, I'll put it on the third, but.
I believe for 15th appearances, he would appear via Zoom.
Okay. All right. Well, see if we can get it done. Probable cause conference April 3rd, 2025, 9 a.m. Or as your invite indicates, bond continued. All right. Thank you.
Thank you.
Court calls case people versus Harold Dennis.
Joseph and all that people.
Stephanie Cannon, on behalf of Mr. Dennis, who's appearing to my right. Mr. Dennis, you can hold up for, take your name for the record.
All right.
Your Honor, we are requesting a 2-week adjournment of this case for mitigation purposes.
That objection, probable cause April 3rd, 2025, 9 a.m. Bond continued.
Thank you.
Court calls case of the people versus, is it a Jalen King?
Alexander, on behalf of the Your Honor.
Stephanie Cannon, on behalf of Mr. King, who's appearing to my right. Mr. King, could you please state your name for the record? Mr. King is electing to waive, Your Honor, up to circuit court for resolution.
Sir, is that correct? You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that here. You'll proceed to circuit court for further resolution. All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Ms. Cannon.
Thank you, Your Honor. We would waive the formal reading of the information and we stand mute as to the charges.
Defendant have a waive formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
March 31st at 1:30 before Judge.
March 31st, 2025, 1:30 before Judge Hammoud.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Bond continued. Court calls case of the people versus Jermaine Fletcher.
Your Honor, Alexis, we're answering on behalf of
He's in Zoom.
He is on Zoom.
You sound as surprised as us.
I misinterpreted. I sent him the Zoom link and he said I'm in the courtroom. So I thought that meant physically.
Oh,
in the Zoom
I
courtroom.
see. You know, you only get to use that once on your birthday. Go ahead.
Mr. Fletcher, could you state your full name?
Yes, Jermaine Fletcher.
In your honor, at this time, discovery is complete. We are just requesting a preliminary exam.
People have their witnesses available the first.
We'll try, Your Honor. I'm having difficulty seeing the defendant.
Kind of a mystic thing. I see him.
But as long as you can.
Yeah, I can.
I'm sorry, it might be the
Yeah.
lights.
Yeah, it's definitely the light. Oh, there he is. Okay.
April 1st, thank you.
Preliminary examination in person, April 1st, 2025, 9 a.m. That's before Judge Perry.
Thank you.
Bond continued. Thank you.
Thank you.
Court calls case People versus Robert Mitchell.
Echelon the people.
Assistant Public Defender Chelsea Virgil, with and on behalf of Robert Mitchell. Mr. Mitchell, please state your name.
Robert Mitchell.
You're asking to adjourn this stage if possible to April 10th.
Probable cause conference without objection, April 10th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Gabriel Smith.
And then on behalf of the people, Your Honor.
For the Acting Assistant Public Defender with on behalf of Mr. Gabriel Smith, who is a custodian.
Mr. Smith, could you state your name for the court?
Thank you.
Your Honor, there has been no offer conveyed at this time. I believe, to my knowledge, discovery is complete, so we would ask that this matter be set to preliminary.
People have their witnesses available the first. Preliminary examination in person, April 1st, 2025, 9 a.m. That's going to be before Judge Washington. Bond will continue. Thank you.
Thank you.
Court calls case of the People versus Robert Gillette.
Echelon the people.
Brian Bowling on behalf of Mr. Gillette. Mr. Gillette. Your Honor, I have been unable to reach my client in advance of today's hearing. I'd ask for you to consider adjourning the proper call conference to give me another opportunity to get in touch with this gentleman.
He did so well on the last case, but no. Bench warrant will issue for defendant's failure to appear. Bond set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thank you.
Court calls the case the People versus Anatoly Zabriskie.
And then on behalf of the people, Your Honor.
Zabriskie. I have it written down phonetically. She told me yesterday.
It's Zabriskie.
Zabriskie.
Yes, I remember from the last time because
He said, that's what I said. I said I wasn't going to offend him by trying to pronounce it. He said it's actually really easy.
it is easy. His name's easy. He said it the last time, but as I told him the last time, there were just way too many consonants at the end, and I didn't know what to do with it.
Brian Bowling on behalf of Mr. Zabriskie.
Yeah.
Your Honor, we're leaving discovery to be complete. We're asking the matter to be set.
People have their witnesses available the first. All right. Preliminary examination in person, April 1st, 2025, 9 a.m. That is before Judge Perry.
Thank you.
Take care, Mr. Zabriskie. I don't have to say the name again, so I'm good. All right. Court calls the case of the People versus Brandon Jeevers.
And then on behalf of the people, Your Honor. Assistant Public Defender Chelsea Virgil, with and on behalf of Brandon Pierce.
Thank you.
Yeah, we are requesting a short adjournment in this case, and I would ask to address the bond conditions.
April 3rd, 2025, 9 a.m. for discovery. All right, yes.
We are asking three things today.
Three
things for the court to consider today.
Three.
First,
Okay, no, go ahead.
sorry, I apologize. Please bear with me. So the first.
I don't have a choice. Three things. Go ahead.
First being, he's asking to have phone contact with his daughter. His daughter is not sure of a complaining witness and lives with his mother out of state. That is the first request for that phone contact. The second request is to do oral swab testing for drugs and alcohol instead of a urine test. My client has been having difficulty with that. I'll just leave it at that. I believe that the oral swab test, although slightly more expensive, would be just as accurate for drugs and alcohol. I believe he's been compliant so far. The third request, and I think most important to my client's well-being, is we're requesting to end the no-go-to order for the current Michigan Avenue address. I believe that a complaining witness lives elsewhere, out of state. My client did a civil standby, and she and all her belongings were gone. I believe the prosecution has confirmed that she is living out of state. So we would ask to change the no-go-to order to wherever she is living to further protect her. I would note that he has been out of custody for a week now. He's been compliant during that time. He started going to therapy and doing anger management classes. So he's proud to say he's doing well, staying sober, and would like to just continue and keep looking for a job, continue complying with his bond. You would consider those requests, Your Honor.
Respond.
Your Honor, I have no objection to the no-go-to. She is not residing in the state anymore. As for the other requests, I would leave it in the court's discretion. I did just want to ask, is he currently on a tether? So I would leave it in the court's discretion for everything else as long as he's remaining on the tether.
All right. So we will amend the tether so that he can go to that address, because I think that address is blocked on the tether, or at least, okay. So that, and that's for the Michigan Avenue address. With reference was, let me ask this. The telephone contact with his daughter, was his daughter a protected person under the bond conditions? Is that what happened?
I believe so. Yeah, so we're asking for.
Okay, so is it that the daughter then lives with?
I believe the daughter we're referencing here is not the daughter of the victim. However, she is on our bond form because in the report, the victim had stated that at some point previously he had struck the daughter in the head prior to this report, but this is not the daughter with the victim. It's separate child.
Council approach, please.
Yes.
You'll make note of this. And all of your office should, because it won't happen again. I'm going to grant all three of your requests. Right, so I'm going to allow him to do oral swabs as opposed to the urine. I am going to also allow contact with the daughter, remove that provision from the daughter, and I'm deleting the no-go-to provision for Michigan Avenue. In all other respects, this bond will continue. Thank you. Court calls the case, People versus Alton Ford.
As the line for the people.
His attorney is not. Yeah. State your name, sir. Did he file an appearance? He did.
Mm-hmm.
I have no idea where your attorney is. Was this the second time?
I think it's the third time.
Oh, I'm sorry.
Fourth time, excuse me, fourth time.
Fourth time that he's not appeared?
So I have 2:20, he was here, but you didn't have an appearance.
Right.
On 2:13, Mr. Dox did not appear. On 3:06, no Mr. Dox. And, yeah.
All right. Sir, what do you want me to do? I mean, well, I'm gonna tell you, I'm gonna show cause him. And he's gonna have to explain to me why he's not here, because this is unacceptable. That's number one. But your case is also not moving along. And so,
We did an evidentiary hearing a week ago in circuit court downtown, and he was aware it is, I don't know what delay.
so here's the options. Here's what I can do for you, sir. I can, because he's substituted in this case for the public defender. I can strike his appearance and let the public defender represent you so you have somebody here. Or I can adjourn it out again and hope he shows. I have a feeling he'll show for my show cause. Because that, well, I guess he doesn't have to, but just adjourn it out 2 weeks and show cause him.
Yeah.
All right. So what I'll do is probable cause conference, I'll adjourn it to April 3rd, 2025, 9 a.m. And I'm going to issue an order to show cause for McCann. Oh, that's fine, but I'll do it that way.
Okay.
I'll do it. Order to show cause for Attorney Dox. Then you'll take this and do that. All right, your bond at this time will continue. All right, sir? Thank you.
She's in.
Court does call the case People versus Krista, is it Riopel?
That's the one in the people.
We've got to get her unmuted. All right.
Your Honor, we are asking for an adjournment. We've been trying to get mitigation for Ms. Ramco. However, our office, our AIM team is having getting access to bail permissions from the facility.
They had that all worked out.
Fortunately not another today, but I think there was something that they need from the attorney, so we have sent that over to them. So
April 10th, 2025, 9 a.m. Bond continued.
we'll be seeing you soon, Ms. Ramco, okay?
All right, thank you.
Thank you, Jim. Court does call the case of the People versus Kyle Burmeister.
James Gladfelski on behalf of Mr. Burmeister is approaching. We are in receipt of the community corrections report. I can advise the court that it is my understanding, and I believe he actually has the pill bottles to verify, he has prescriptions for the benzodiazepine and buprenorphine. My client does not have prescriptions for alcohol.
He certainly does not, and that's prohibited, Mr. Allen.
Your Honor, if I could just make one.
Go ahead, make your argument. I'll let you say what you're gonna say.
Records I have obtained so far have shown me that leading up to and prior for probably several years, Mr. Burmeister has been a patient at Washtenaw Community Mental Health. He also sees addiction specialists over at IHA at St. Joe's Hospital, which is his aftercare, which he is continuing after he completed the residential Oakdale Recovery Center, which I have proof right here. So we have a situation, Judge, where somebody who is struggling with addiction, doing as much as he can to address that, to be clean and sober, and getting help from several medical professionals. My request, Your Honor, is that the court consider an ankle alcohol tether to monitor him 24/7. I know he wants to be sober. He's just struggling. And as far as addiction, this court is well aware that It's not an easy process, so I would ask that you keep him on bond with the condition that he be on the tether.
He didn't go to community corrections. We sent him over to community corrections. He comes back positive.
I understand, Your Honor. For at least several of those weeks, he was in program. And I have proof to verify that. So getting help, detoxing, getting inpatient rehab care.
Set this for April 3rd, 2025, 9 a.m. I don't need a response from the people. Defendant's bond is revoked. Defendant's remain. Court calls the case of People versus Sincere Godwin.
Senator Johnson, on behalf of the people.
I think they're probably finger to nothing. Hey, I can really on behalf of, but unfortunately not. Sincere.
Is that why we had that saunter up to the podium? Okay. Thought it was gonna get better the longer you took. Okay.
Unfortunately, Your Honor, Mr. Godwin is not here. His mother is present, though. She was, she'd spoken with him this morning, and she wanted to make sure that she was here, so we know that he's got support, but unfortunately, she has not been able to contact him.
Either.
Yeah.
Bench warrant will issue for defendant's failure to appear. Bond 10,000 cash surety. That warrant will issue immediately. All right, thank you. Court does call the case of the People versus Cameron Hallen.
Judge Simpson, call him.
Brian Bowley on behalf of Mr. Hanlon, who's approaching your honor.
Hanlon, I'm sorry.
Cameron Hanlon. Judge, Mr. Hanlon would like to hire an attorney to represent him. I understand he's made some progress towards that end. We just have to.
How long does he think it's gonna take?
3 weeks.
We'll adjourn the probable cause conference to April 10th, 2025, 9 a.m. Sir, I'll adjourn it for that purpose for you to hire counsel. I will not grant another adjournment for that purpose. You understand that?
Yes.
Bond continue. Thank you. Court calls the case of the People versus Christopher Holt.
Again, Jonathan, on behalf of the people. It's yeah.
Is it? No, there's a pep in her step. She's got a client.
The court should be in receipt of.
I am.
You are.
I have a plea form that indicates that the defendant would be pleading no contest to an added count. I got it. To an added count 2 of larceny 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. Sentencing recommendation for probation, no go to Gainsley Electric, and restitution to be determined approximately $1,000. That's the court's full understanding of the agreement.
That is my time.
Oh. Sir, you did not state your name for the record.
Christopher Holt.
All right. May I have him sworn?
Raise the right hand. You solemnly swear to tell the testimony about the truth, the whole truth, and nothing but the truth, so help you God. Yes. Raise your name. Christopher Holt.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken or the subject matter of the larceny. If that's greater than $2,000, that would become the maximum fine. Do you understand that, sir? Do you understand what a no contest plea is?
Yes.
Okay. That was not a definite yes. Do you understand what it is? If you don't, I'll try to explain it. All right. I'm going to read and have reviewed part of it. We'll finish that up. The police report. I will take those facts as true. All right. Determine whether or not there's been a crime committed. You haven't done that, whether or not this crime has been committed. Do you understand that, sir? All right. The other part you need to understand is it means that no contest plea means that you're not further desirous or wanting to contest the charge. You understand that? I need you to verbalize. Yes. All right. Yes, the other part you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that? All right. Any other questions you might have regarding a no contest plea? All right. Basis for the no contest plea? All right. So, Mr. Holt, to the charge of larceny 200 to 1,000, how do you plead? All right. Now, you understand that by pleading no contest, you will not have a trial of any kind. All right. You signed an advice of rights form. Is that correct? Do you have any questions regarding any of those rights? All right. Look at paragraph 5. You'll see it on the podium if she'll move her computer. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole? Has anybody promised you anything
No, Your Honor.
other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will.
Yes, Your Honor.
All right, the court has been handed and has, I think, satisfactorily reviewed Pittsfield Township Department of Public Safety report for their case number 252829. Any objection to the court having reviewed that report? Based upon the court's review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Satisfied that you have, Your Honor.
Defendant satisfied with it.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be April 30th, 2025, 12 noon. That's before me. All right. Defendant's bond in this case will continue. All right. Thank you. And he might want to, my probation department's right down the hallway on your left. You may want to just stop down there and check in with them and get it started. All right. Thank you. Court calls case People versus Craig Jones.
Special line of people. Order Alexis, tonight on behalf of Mr. Jones, who's approaching. Mr. Jones, could you just say your full name?
Craig Jones.
Right.
Your Honor, we have worked out a global resolution of Mr. Jones' cases. A part of that resolution would require him to plead on his 2 misdemeanor cases before we resolve this
case.
Those are not set until April 2nd and April 10th, so if we could go to the 17th, that would be perfect.
That's correct, Your Honor. He has 2 pending domestic violence cases which he needs to plead on in order to resolve this case.
Gotcha. All right. Probable cause conference April 17th, 2025, 9 a.m. or as your invite indicates, bond will continue. All right, thank you. Court calls the case of the People versus Lamar Jones.
And then on behalf of the people, Your Honor.
Brian Bowling, on behalf of Mr. Jones, Your Honor. State your name there.
All right, thank you.
Your Honor, we've reached a resolution in this case. Excuse me. That would be for Mr. Jones to plead guilty to counts, I believe, 5 and 6. Misdemeanor count.
That's correct, Your Honor. We agree that count 6 would be under sentencing under 4A.
Counsel approach. Indicated to counsel at the bench says I'm not going to take his plea today. I don't mind taking his plea, but he's got a bond violation. And so we'll have to work all of that out in terms of that for violation at community corrections. So what I'm going to do is I'm going to adjourn his probable cause. I'll just adjourn it out 1 week to the 27th, 2025, 9 a.m. At this point, the defendant's bond is revoked. Defendant's remain. Thank you. Court calls case People versus Marcus Jones.
Jonathan Evans, on behalf of the people.
Ready, Judge? Show Feaster, Assistant Public Defender, on behalf of Mr. Jones. Please state your name for the record, sir.
Thank you. Need to take your hands out of your pocket.
Thank you, Judge. Mr. Evans has made a very fair offer in this case, however.
What? Yeah. Oh, I'm sorry. I did. That just came out. It just. I'm sorry.
That it's stipulated. So Mr. Jones indicates that he would like to get some treatment, Judge.
Okay.
So what I'm gonna do is go around for this to release, to like the program.
We tried that. Oh, gotcha. Okay. Probable cause conference, I'll adjourn it to April 10th, 2025, 9 a.m. Bond continued. Thank you. Court does call the case, People versus Jeffrey Moore.
That's a lot of people.
Ready to enforce those things for the Mr. Jeffrey Moore. Mr. Moore, the commissioner, Jeffrey Moore.
You're requesting, I got you.
Yes.
April 3rd, 2025, 9 a.m.
Thank you.
Without objection, bond continued. Thank you. Court calls the case, People versus Zachary Copella, is it Jacobs? Yeah. What do you want now? That was really good, Judge Simpson.
Appearing on behalf of Mr. Cole. Will you state your name for the record, sir?
Oh, I'm sorry. Zachary Copella from Dacus.
Judge, we asked this item set for preliminary exam.
All discovery is complete.
For knowledge, yes.
And would the people have their witnesses available April 1st? Preliminary examination in person will be set April 1st, 2025, 9 a.m. before Judge Washington.
Thank you.
Court calls the case, People versus Natasha Lawson.
Actually, let me go. Ms. Lawson, will you please state your name for the record?
Natasha Lawson.
All right, court. No, okay, I got it down here. So I have a plea agreement that indicates that the defendant will be pleading guilty to 2 counts. The stated count 2 of operating with a controlled substance, second offense, and also an added count 4 of controlled substance use, the 1-year offense. Upon their successful guilty plea to those charges, counts 1 and 3 will be dismissed.
That is correct, Your Honor.
That is correct.
May I have her sworn?
You solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth.
Yes. Natasha Lawson.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to 2 charges. Is that your understanding?
Yes.
All right. First of all, the court's understanding that you're going to be pleading. We don't have it. Hold on a second. That's that you'll be pleading guilty to the charge of operating a motor vehicle with the presence of a controlled substance. All right, second offense. That's a misdemeanor, punishable by $200 to $1,000 fine plus court costs, 5 days to 1 year in jail, community service, and any rehabilitative programs the court deems necessary. Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that? And also an added count 4 of use of cocaine. That's a misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that? You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
All right. Understanding all of that, do you still wish to plead?
Yes.
All right. So to the charge of operating with the presence of a controlled substance, how do you plead?
Yes.
To the charge of use of a controlled substance, how do you plead?
Yes.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights, which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of right?
Yeah.
Are you on probation or parole?
Yes.
Okay, were you on probation or parole at the time of this offense?
Yes.
All right. Was it?
No, I'm
No, not yet.
Judge Bennett. She was not. She was sentenced to probation 2 months after this offense happened.
Got it. All right. Anybody promise you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce? You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And also because you believe that you're indeed guilty?
Yes.
February 16, 2024, at the location of North Harris Road and East Michigan Avenue, Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes.
And what was that substance?
Correct.
All right. Were you stopped by the police on that day?
Yes.
And were you ultimately arrested?
Yes.
Were you taken to the hospital for a blood draw?
Yes.
Did that blood draw show evidence of either the cocaine and or its derivative?
Yes.
All right. Do you have any reason to dispute those results?
No.
And had you previously been convicted of operating while intoxicated on or about September 4th, 2019 in the 14B District Court?
Yes.
All right. And on that same date, you did use cocaine?
On that time?
No, on the February
Oh, yes.
16th date. You used crack cocaine? You knew what you were using?
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept the defendant's plea?
The people are satisfied. Defense is satisfied.
The court will accept the defendant's pleas of guilty to counts 2 and 4. Counts 1 and 3, are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
May 1st at 10 a.m. before Judge Washington.
May 1st, 2025, 10 a.m. before Judge Washington. Bond will continue. Thank you. Court calls the case of the people versus Latrice Lee.
Epsilon, the people.
Assistant Public Defender, Shelby Bridgefield, person on behalf of the please state your name.
Thank you.
We are asking to adjourn form right here, for discussion.
Probable cause conference will be adjourned April 3rd, 2025. 9 a.m. or as your invite indicates, bond will continue.
Thank you.
Thank you. Court calls case of the people versus. Is it Ato Maynard?
And then on behalf of people, Your Honor. Stephanie Cannon, Mr. Mayor, Mr. to my right. Mr. Mayor, when you were at the podium, please state your name for the record.
Okay. You're requesting an adjournment of PCC.
Yes, Your Honor.
April 3rd, 2025, without objection, 9 a.m. or as your invite indicates, bond with its conditions will continue. Thank you. Court calls case people versus Giovanni Moot.
Josephine Goldman, people. Mr. Collins is not here.
I know, but he's been doing other stuff all day.
Sorry, Your Honor.
You were doing what?
I'm here and my cell phone's not ringing.
Okay. Do you have a client?
I do.
Okay.
Public Defender Jay Rob, on behalf of Mr. here soon.
All right. Mr. Moot, can you state your name, please, sir?
My name is Giovanni Michael Moot.
All right. And he's waiving on both cases?
That is correct.
All right. Mr. Moon, is that correct that you're waiving your right to a preliminary examination?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Correct.
All right. You understand you will not have that hearing, that you'll proceed to circuit court for further resolution of these cases.
Yes, sir.
People also waive their right in both cases.
We do, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Bellinger.
Your Honor, we acknowledge we see that.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in these matters will be set for May 13th, 2025, 1:30 before Judge.
Thank you.
Thank you.
Thank you, Mr. Simpson. You have a great day.
You do the same, sir.
Thank you.
Court calls case People versus Taisha Morgan. Nope. Bench warrant will issue for defendant's failure to appear. Bond 10,000, cash surety. That warrant will issue immediately. Court calls case of the People versus Megan Moses.
You're gonna jump in and have people. Well, we go, Mr. and Assistant Public Defender, hearing on behalf of the making motions.
Whoa.
Watching down further around,
It's like getting a pattern. Bench warrant 10,000, cash surety. Warrant will issue immediately. Thank you. Court calls case People versus Matthew Olette.
Joseph involvement. You're requesting a 2-week adjournment.
Yes, Your Honor, we are.
Hearing no objection. April 3rd, 2025, 9 a.m. As your invite indicates, bond continues. Thank you. Court calls the case People versus Antoine Patterson.
Your Honor, Jake Kennedy, we have people, Assistant Public Defender, get on, Johnny Patterson, both of Your Honor.
That's all,
Thank you.
Your Honor, we are requesting a final 2-week adjournment on this. There is an offer that has been relayed in this matter. I am asking for further consideration. Either way, next PCC, we're going to either have a waiver or a plea.
April 3rd, 2025, 9 a.m. Bond continues.
Thank you.
Thank you, sir.
Thank you, Your Honor.
Court calls case People versus Thurman Pool.
Public Defender Luxembourg, present on behalf of Chairman Poole. Mr. Poole, state your name.
Thank you.
Mayor, Mr. Poole would like to waive his right to a preliminary exam. He is currently signing the form.
All right. Sir, you understand you're waiving your right to a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
We acknowledge receiving the information, waive its formal reading and stand mute.
Defendant every waive formal reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for May 15th, 2025, 1:30, Judge Slay. Bond continued. Thank you. Court calls case of the People versus Mark Richardson.
Joseph involvement, people.
Brian Ball, on behalf of Mr. Richardson.
He's also waiving his right.
That's correct.
Sir, is it correct you're waiving your right to a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing, you'll proceed to circuit court for further resolution. People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count one with two following.
Your Honor, I'll receive the information with from reading and standing.
Defendant having waived formal reading, standing mute. Both counts, court will enter a not guilty plea. Pretrial will be set for May 12, 2025, 1:30, Judge Hamud.
Thank you, Judge.
Thank you. Bond continued. Court calls the case of the people versus Kirby Snyder.
That's the one, it's the people.
Brian, we're going to be having this later. Approaching. Judge, for an adjournment, the AIM division of our office is very close to completing, or really basically has completed a mitigation report that just needs to be reviewed with Ms. Schneider.
And then sent over. Okay. Probable cause conference, April 10th. Will that work for you?
Yes.
Thank you. April 10th, 2025, 9 a.m. Bond continued. Thank you.
Thank you.
Court calls the case people versus Julian Tabon.
Approaching, and could you just say this one?
Julian Taylor.
And Your Honor, at this point, we are still trying to negotiate an offer. Mr. Tabor has provided proof that he got a valid driver's license this week. We're still not quite,
Not quite there.
yeah.
Okay. Probable cause conference be adjourned April 3rd, 2025, 9 a.m. or as your invite indicates, bond will continue. Court does call the case people versus Carl Tesson.
Defendant shall be very accurately, Your Honor. On behalf of Mr. Carl Tesson, who's approaching Mr. Tesson, state your name for the record, please. Judge, you're requesting an adjournment today.
Probable cause conference, April 3rd, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls case of the people versus Deshaun Tompkins.
Assistant Public Defender Chelsea Virgil, with him on behalf of Deshaun and Mr. Tompkins. Please state your name.
Deshaun.
Thank you. You're requesting an adjournment. I see. Well, April 3rd, 2025, 9 a.m. Bond continued. Thank you. Court does call the case people versus Douglas Wren on 3 cases.
And Assistant Public Defender Chandra Kariakin, Your Honor. On behalf of Mr. Wren, who's approaching Mr. Wren, state your name for the record, please.
Douglas Wren.
He's waiving preliminary examination in all of these matters.
That is correct, Your Honor. He has been accepted into the circuit court.
Strike court. All right. Sir, is that correct? You're waiving preliminary examination?
Yes, sir.
All right. You understand that the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and you committed them. You understand that?
Yes.
And you understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their preliminary examination having been waived. Defendant is bound over to circuit court on each. Every case has 1 count, correct? On all 3 counts. Yes. Secretary.
We acknowledge receipt of the information, Your Honor. We waive formal readings and mute and ask for permission. sentence or not guilty plea.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pre-trial in these matters will be set for
May 15th at 1:30 p.m. with Judge Slay.
May 15th, 2025, 1:30, Judge Slay.
Thank you so much, Your Honor.
All right. Bond will continue. Good luck to you, sir.
Thank you.
Thank you. Recall case. People versus Desiree Walker Johnson.
Pass the line to the people.
Carolyn Foster Tucker on behalf of Desiree Walker Johnson, Mr. Coaching.
You found her? Thank you.
And Your Honor, we're requesting an adjournment. I just received this case yesterday.
Probable cause conference without objection, April 3rd, 2000. April 3rd, 2025, 9 a.m. Where's your invite indicate? Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Zane. Is it Huckabee?
Joseph is on that people.
First time here, Judge.
I couldn't tell. You're pointing that way and they're all like, no.
I appreciate Brother Council's.
Those two you shouldn't have trusted, really, because they would have pointed, no, go back into the lockup. Anyway, go ahead.
Well, Judge, the stocks always take any friends you can get.
Yes, all right.
Nothing surprising. Thank you, Your Honor. Charles Noe, P. 75962, appearing on behalf of and with the defendant, Mr. Huckabee.
Okay, can you state your name?
Zane Huckabee.
All right, you're requesting an adjournment.
I am, Your Honor. This is the first PTC in this matter. I've had such conversations with the prosecutor to try to come to some sort of.
Did you say it was a good conversation?
I said with brother prosecutor, Judge.
But did you say it was a good conversation or no?
I don't know. Good is a subjective term. I would say.
All right, fair enough. Go ahead. I was just because I never heard that about a conversation. No, go ahead.
Judge, when we're talking, I need to do some work on a reduction memorandum, some other use discovery. So we are requesting approximately 30 days adjournment so we can get that done. We are willing to waive any statutory requirements for the time for a preliminary exam or another.
Any objection to the 30 days, counsel?
No, Your Honor. Counsel and I have discussed some additional information you'd like to obtain and some that you'd like to submit for people's consideration.
Got it.
Given the circumstances of objection.
Come on. Probable cause conference, April 17th, 2025, 9 a.m. Or as your Zoom invite or your invite indicates. Bond will continue. Thank you.
Thank you. We're going to Zoom. I'm sorry.
Pardon?
I'm checking the date you were saying that.
April 17th.
Okay.
And since you're private counsel, you'll likely be in the afternoon. I said everything at 9 and then they're put in blocks.
That works.
All right.
Thank you.
Thank you.
Okay.
Right. Thank you. Court calls the case People versus Matthew Erickson. Thank you.
Got arrested for an exam date on this matter, please.
All right, discovery is complete.
It is.
And would the people have their witnesses available to first?
We will do our best.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. before Judge Perry. Bond will continue.
Thank you.
Thank you. Court calls the case of the People versus you. Wasn't even going to give it a shot.
Yeah, you're on behalf of Paul Yu. We should be here by Zoom.
Is he? Oh, it's Paul. Okay, well, I could have done that. No, you want to know what it was? The way they had it listed, they had his middle name. And I said, I'm not going to butcher the man's name. Sir, can you please state your name?
Hello, Judge. My name is Paul Yu.
I could have done that. I really could have. All right.
Yeah, we're asking for an exam date. If possible, we can go beyond the first. He needs to make travel arrangements to
From where?
come back. Virginia.
Virginia?
Virginia.
That's a 10-hour drive. He can be, no, anyway, never mind. I don't know how I know that.
Gentlemen, that we have the figure.
Musical prosecutors.
Preliminary examination in person. You 8th or the 15th?
You don't work for us.
Well, you said your client needs to make arrangements to come, so what?
Needs a little bit of lead time, right? So either one.
Either one will work.
Fine.
April 15th, 2025, 9 a.m. before Judge Moore. Bond continued. Thank you. Court calls the case of the People versus Jerry Bingham.
Absolutely.
Is that it for you, Mr. Guerin? Take care.
On behalf of Mr. Bingham, consider yourself to the court. Jerry Bingham.
Thank you.
Your Honor, and something we are asking that this matter be set for preliminary exam.
Discovery is complete.
Yes, Judge.
People have their witnesses available the first.
We'll try, Your Honor.
Preliminary examination in person, April 1st, 2025, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Bond continued. Thank you. Court calls the case of the People versus Sequangela. I knew that. Sequangela. Middleton. How'd you know I was calling that?
I get it. Tell.
Ashley Luggett for the People.
Howard on behalf of Ms. Middleton. So please introduce yourself to the court.
Ma'am, can you state your name?
Oh, I'm sorry, I didn't hear you. Soquangela Middleton.
Thank you.
And Your Honor, we are asking that this matter be set for exam as well.
Discovery is complete.
Yes, Judge.
People have their witnesses available the first.
Will we be able to go one extra week, please, Your Honor?
Why? Too many cases or why are you asking?
Very old case, 2016 case that had a bench warrant for
Fine.
several years.
Your Honor, I am out of the country on the 8th. We move on a week after that to the 15th.
Preliminary examination. I'm gonna quit being so nice.
What?
April 15th, 2025, 9 a.m. That's in person before me. Bond will continue.
Thank you, Your Honor.
Thank you, Judge.
Thank you. Thank you, ma'am.
Okay.
Court calls the case People versus David Lee Furman.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor, 60467.
Rodriguez on behalf of David Furman.
Okay. And you need an adjournment for consideration of what to do with the charges. Is that the?
That's what I'm asking for today, Your Honor.
Actually, Your Honor,
Yes,
the-
sir.
The defendant has paid his rearage in full. He has no ongoing obligation, and we are prepared to dismiss the charges under the condition that he pay his extradition. The extradition fee is $2,643.75. And we would need proof of that brought to court, and we could bring the form for a nulli. So if we're going to adjourn this, I think it ought to be to give the defense an opportunity to get that paid and bring proof.
Mr. Durkis?
In addition to that, there is his bond money.
Hold on 1 second. Mr. Furman?
Yes.
I need you to turn on your camera, please. And state your name, if you would.
David Lee Furman.
Thank you. All right. So Go ahead, Mr. Jerkus.
He's paid, I think there's about a 6,100 or 6,100 in a bond.
But that bond, wasn't that applied to?
Don't know if that was applied yet.
It's been applied.
Okay, so there's currently no money being held by the court. Certainly,
I do not see any funds being held by the court because those would have been paid over on his child support obligation.
I think Mr. Furman heard that. I'm not sure how long it would take him to make that payment. And certainly having the charges drop would be nice, but I would need an opportunity to discuss that with him. I think we could.
All right, why don't you do this? Figure it out. Let me put this out 2 weeks. You can have your discussion with your client. The people have stated what they're willing to do, and you guys can figure it out. Probable cause conference, I'll adjourn to April 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your
Bond
Honor.
continued.
Wonderful day.
All right, take care, sir. Court does call the case People versus Nicholas Schultz.
Good afternoon, Your Honor. Evan Latrisky appearing on behalf of and with the defendant, Mr. Schultz.
Mr. Schultz, could you state your name, please?
Nicholas Allen Schultz.
There he is. Okay, what are we doing?
Your Honor, I suspect based on the discovery that I have right now that there will be additional charges coming. I think it would be best for the court and the prosecutor and myself if those charges are brought before we have an exam, if we're going to. So I would ask for an adjournment of the PCC, Your Honor.
And are there additional charges?
I'm not sure yet, Your Honor.
Okay.
Well, that's good news.
Yeah, I know. I mean, you want me to put it out so you can at least look at it and somebody can?
Yes, Your Honor. If it's okay with defense counsel, we could look at that April 10th, or I'm sorry, yes, April 10th date, if it's okay with them.
Yes, Your Honor, that'll work.
All right. Probable cause, April 10th, 2025. I'll set it at 9 a.m., but you'll get a block assignment, which will likely be in the afternoon.
And
thank you, Your Honor.
I'm putting my email address in the chat. If you could shoot me an email, I'd really appreciate that.
I'm sorry, I didn't understand that.
Just put my email address in the chat. If you could email me, I'd appreciate it.
You got it. Okay.
All right. Thank you.
Thank you. Bye-bye.
Court calls the case People versus Kendall Warford.
Joseph Kendall, Keeper.
And good afternoon, Your Honor. Attorney Ron McCool, number 8231 on behalf of Kendall Wolford, who's also on screen. Ms. Wolford, tell the judge your name.
Kendall Maya Wofford.
Thank you. All right, what are we doing?
Your Honor, we're going to ask for another PCC. We got digital discovery. One of the zip files appears to be out of sync or not extractable. We're just asking if the court would consider that 4/17 date, if the court was so inclined. And I did have a brief
17 to open a zip.
It was the I could do it. There is a week earlier I could do, Judge. It was just me trying to
Great.
the calendar.
I got a week earlier. Here every week. With bells on. Probable cause conference April 10th, 2025, 9 a.m. Bond continued.
Your Honor, bond, may I make one argument?
Okay, thank you.
So my client has an OWI in Shelby that she's currently on bond for. That happened back in September. This is a July case that before Your Honor. She is testing there 2 to 3 times a week. She's tested negative ever since November. I'm just trying to save her a little bit of money, Your Honor. Court consider allowing that testing agency to provide the data to both courts as opposed to the duplicate effort that's going on right now with her alcohol tether?
Well, I guess my only concern is that how often is she testing there?
2 to 3 times per week, Your Honor, ETG. That's correct, right, Ms. Clifford?
Yes, that's correct.
I might consider it on the 10th, but at this point, I'm gonna leave it in place. If you can work something out with the people that they would be satisfied with that testing going on with reports of those ETG results to our community corrections, then I don't know that I'm gonna have a great objection to.
Okay, thank you, Your Honor. And question, if I may, you have us coming back on the 10th, Your Honor, would that be the AM or the PM?
It'd likely be in the PM.
I'm sorry, Your Honor, is it all possible? I know I asked, could I do either the 17th or the 3rd in the PM for April 3rd?
Okay, we'll do April 3rd.
Thank you, Your Honor.
All right, thank you. Bond will continue. Court calls the case, People versus Demetrius Caldwell.
People.
And good afternoon, Your Honor. Sydney Rushing appearing on behalf of Mr. Caldwell. Mr. Caldwell, can you unmute your mic, start your camera, and state your name for the record, please?
Demetrius Caldwell.
Thank you.
All right, you're requesting. All right, has he been interviewed yet?
Your Honor, I'm not sure. I reached out today regarding asking if there was a report that was done as of yet, and there is not a report. I don't have that answer as to the interview part of that, which obviously if he hasn't been interviewed, there's not a report, huh?
Right, well, they could have done the report and it be delayed.
Right.
Go ahead.
I don't think he's probably been interviewed yet, Your Honor. I emailed the CFB to get more information. The court may recall he was pending competency in 15.
Correct.
Came back in competency. So just looking to get that same report here.
Yes.
So I don't think he's probably
Been seen
It's
again.
been pretty quick. Yeah, it's only been a few weeks.
All right, so let's do this. I'm gonna kick it out at least 30 days. And then if we get the report, we can move the hearing date up.
Perfect.
So April 24th,
That's a good day for me, Judge.
Thank you, Your Honor.
2025, 9 a.m. or as your invite indicates. All right, thank you.
Thank you, Judge. Have a great day to you and your wonderful staff.
Thank you.
Yes, you too.
Easy one today.
Thank you, ma'am. Court does call the case of the People versus Andrea Butkovich.
Deborah Schlossel on behalf of Ms. Butkovich, please state your name.
Andrea Butkovich.
Okay, what are we doing?
Your Honor, I do believe we have this resolved. It's just a matter of the payment and the mechanism. And I think Mr. Emmons and I have resolved that today. So I just have to make arrangements with Ms. Butkovich and her family for the payment to be made. And then I think we will have a plea agreement for the court if we can have one more adjournment.
Hey, how much time do you need to get that accomplished?
2 or 3 weeks, Your Honor.
April 3rd, 2025, 9 a.m.
Thank you,
Or as
Your
your
Honor.
invite indicates. Bond continued. Thank you.
All right, thanks.
Thank you.
Court does call the case, People versus Lawrence David.
Good afternoon, Your Honor.
Good afternoon.
Attorney Nicole Blank. Sorry, go ahead.
No, please, go ahead.
Attorney Nicole Blank Becker, on behalf of my client, Mr. Lawrence David. He is attending via Zoom, waiving his rights to be in court, and we are prepared for today, of which I understand is going to be an adjournment. And maybe Madam Prosecutor wants to put it on the record, or I'm happy to.
First of all, Mr. David, can you state your name, please, sir?
Lawrence David.
All right, go ahead, Ms. Rice.
Good afternoon, Your Honor. Amy Weiser, appearing on behalf of the people.
All right, what are we doing?
And it's my understanding that defense counsel spoke with Ms. Tanha, and there is going to be a short adjournment, a request for a short adjournment. And I apologize, I cannot get on the network to see what the reason for the adjournment was, but I knew that we were adjourning it. I didn't know if you wanted additional discovery or plea negotiations or a little bit of both.
You know what? Unfortunately, I think her son had to go to the ER last night, and so she asked if we
Okay,
move it to sometime in April. So no objection to doing that. So that's what we're gonna do.
probable cause, will the 3rd or the 10th work better for you?
Your Honor, the 3rd or the 10th. Let me ask, Your Honor, if you would so indulge, can we do the 24th? Because we are in trial at the beginning of that month and then out of town that 3rd week, it looks like. The 24th is a Thursday.
Any, no objection to that? All right, probable cause will be adjourned April 24th, 2025. I set it at 9, but you'll likely be in the afternoon, counsel.
Thank you very much, Your Honor. Nice to see you.
Thank you.
Thank you,
Take
everyone.
care.
Bye-bye.
Court does call the case of the People versus Don Lee.
Alexander, you have the Your Honor.
Good afternoon, I understand Bernstein with on behalf of Don Lee.
Record should reflect Mr. Lee is present. All right, this is People's motion. For this, I don't think I received a response from defense regarding it.
No, I don't have a response, and I think it's made actually shortcut everything. I mean, realistically, I would need to listen to the phone calls, the form of intelligent response to the motion. I don't have the phone calls yet. Sure, the Senate will send them to me right away. Mr. Lee has a PCC for next Thursday. We can get some time to listen to him and see what we're talking about. And I think they can just resolve the matter that way if that works.
All right, then, well, that will work from the court standpoint. Was there anything other requests from the people?
There wasn't any other request, just to have his phone privileges available. I did want to let the defense counsel know that for each of the numbers that he's called for the victim, I believe we're looking at, there's 66 to this one number, 135 that were completed, and then 22 to a different number. So it might be all the calls he's been making to the victim, as well as the mail he's been trying to send to the victim as well.
I'll clear my week, Your Honor, and make sure.
All right, and as I had indicated, or you probably got a copy of, I don't see it in our file. Our order revoking. Did that get?
Oh, yeah, I feel like it's.
It's over.
Yeah.
On the 18th. On the 18th, I had preliminarily granted the people's request. And so at this time, since we've had the hearing until such time as defense counsel raises it, I'm going to revoke his phone privileges permanently. All right, thank you. Court does call the case of the People versus Anthony Taylor.
Good afternoon, Your Honor. Taking care of the people. Hey, Your Honor. Good afternoon, James Vakowski appearing on behalf of Mr. Taylor, who is approaching.
Yes.
Station and Anthony Taylor.
This is your motion. Go ahead.
Your Honor, we are asking the court to modify what is currently a $300,000 cash or surety bond. As I've outlined pretty extensively in my motion, Mr. Taylor has no prior convictions, and of course, then we have no prior violent history or history of absconding or not showing court hearings. He served honorably in the Marine Corps in his younger adult years and was honorably discharged. He also graduated from Eastern Michigan University back in 2006, I believe it was, with a bachelor's in business and computer science, and has worked in the IT security field for 20-some years or so. This is a gentleman who has never had any issues with the law outside of the accusations made in this case, which, with reference to what the people have articulated in their response, I would just note that even assuming there's some truth to these allegations, we dispute and we'll put our defense forward as we can through this process. There's no allegations of any sort of violence or
behavior that would, especially when these children now are under the family court jurisdiction and also being supervised by DHHS, I assume, because of the CPS termination cases pending. My client will not be anywhere near these kids without there being some kind of arrangements for supervised visits, which I think is highly unlikely until this case is fully litigated. Lastly, I spoke to my client's mother. Her name is Mary, and I believe she's 78 years old. Lives in Belleville on the home where he was raised, along with 9 other siblings. She sounds like a wonderful, very religious woman. He told me that she has relied on his assistance at the house. He could live there with her. He could be placed on house arrest there. And I'm not exactly sure where the children's mother lives, but I think it's somewhere in Ann Arbor. So Belleville from Ann Arbor is a significant distance, and again, the kids would be under their mom's her custody. And I think a significantly lower cash 10% bond with strict conditions like house arrest and GPS tether would be certainly sufficient in the broader context within which Mr. Taylor appears to this court. So I'm asking the court to consider a reduction to 100,000, 10% with either house arrest, GPS tether, any other conditions the court needs. And if the court even wanted to have his mother appear in court, she's a lovely lady, and I'm sure she'd be able to verify that she would keep him accountable at her residence where he would also be able to help her.
Response.
This time, there are the people would object to any modification of bond and actually ask this court to deny the defendant's bond. As I know, this court is abundantly aware, Michigan Court Rule 6.106B1B allows this court to deny pretrial release to defendant charged with criminal sexual conduct in the first degree if the court finds that proof of the defendant's guilt is evident or the presumption of rape, unless the court finds by clear and convincing evidence the defendant is not likely to present a danger to any other person. I'd like to direct the court's attention to page 7 of my response to the defendant's motion, specifically the allegations substantiating the charge of criminal sexual conduct in the first degree was provided by the minor victim, the defendant's daughter, during a forensic interview at the WCAC, in which she stated that on one occasion, the defendant, she asked the defendant what he was doing, to which he responded, just covering up. The minor victim then disclosed the defendant was touching her vagina with either his head or his hands, and that she believed that her father was either licking or blowing on her vagina. It was unsure if anything was inserted into her vagina, which substantiates the charge of criminal sexual conduct in the first degree. Additionally, Your Honor, I don't believe that there's anything within the defense motion to substantiate a claim that the defendant is neither a danger to the community or is not a flight risk at this time.
Briefly, Your Honor, I think with regard to CSC1 accusation, the last statement that counsel read off, according to the forensic interview, she was unsure if anything was inserted. There may be stronger evidence for a CSC2, but in terms of bond not being permitted on CSC1, that's like a murder 2 or murder 1 charge. I just don't think it is abundantly clear that the evidence substantiates that.
Yeah, but your argument fails to take into account what will constitute penetration on a CSC.
Well, I understand that at least under the law, any penetration, no matter how slight, can be sufficient for a CSC1 conviction, but this is a case where I believe that was the sum and substance of her statement in terms of the CSC1 charge. And I don't believe there's any other evidence that would otherwise either corroborate or help prove that in any fashion like forensic evidence. So we may well be having a trial ultimately on CSC2 charges, but we
Why? I don't understand that argument. I don't understand that argument.
Well, whether or not there's probable cause for a bind over on the CSC one charge will be determined at some future date.
Yeah, but again, your argument has a problem. Your argument has a problem in the sense that if the question's asked or what is said is, was anything inserted, that in and of itself can be a certain statement. That doesn't mean that there wasn't a CSC one if there is other penetration.
I believe I'm following Your Honor, and I don't believe there's.
I don't think you
any
are.
Evidence that there was penetration.
Pardon?
I don't believe there is any evidence that there was penetration. There may be evidence of allegations of contact, but I don't believe, from what I've seen so far, there's evidence of penetration.
I think the case law, as I read it, based upon what this individual is saying, would constitute penetration.
I do have the monetary instructions. before we drive to read aloud.
No, I don't need them. I know what they say. I mean, and so then the question becomes on that CSC one, if that is testified to, what's been stated, that could constitute a CSC one. And it would seem to me that if this witness gets up there and says that, it is a great likelihood that this defendant would be convicted. I'm not saying he will be, but I'm just saying that's not what I have to decide as to whether or not he will be at this time.
And all I can say at this stage is we have not had testimony. There has not been the process of cross-examination to get clarity on what she meant by what she said. So that will be our next stage in this process. I would just ask the court.
So why wouldn't I, under the court rule, given what has been presented to the court, actually change his bond and deny it at this point?
Because I don't think the evidence is abundant, or it's so clear that there could be a reasonable question to be decided at preliminary exam as to whether or not the CSC one.
So why wouldn't I deny his bond at this point, let the exam happen, and then whoever has it revisit the bond? But based on what's in front of me at this point, why wouldn't I just deny his bond?
Well, I think certainly the court would be within its right to do so, and I understand that certainly is a way these cases are handled in many situations. I just think that it's also, there's a lot of compelling reasons why a bond reduction would be appropriate given the safeguards the court can put in place. Even bearing in mind the context of the allegations of the situation. Not a random stranger. He's never had a history of just going out there violently attacking them. I understand what the allegations are.
Yeah, but I don't need all of, I understand what you're saying, but I don't need all of that under the court rule, right?
I think that it's still, these are still factors for the court to weigh out to determine whether or not the no bond or some other bond is appropriate. Because I personally don't think that the no bond portion of the court rule applies given the facts as we know them. This is not such an abundantly strong case that there may not be a reasonable dispute or a reasonable issue, at least at preliminary exam and subsequently at trial, even if it is found. So from my vantage point, I still think there are reasons to look at all the factors.
Anything else from the people? Well, Mr. Rafetsky, if I do that, is there anything, if I deny his bond, is there anything, or consider denying his bond? I mean, the one thing is that the court would then have to find that he's not a flight risk. But that almost shifts it. I mean, so tell me why he would not be a flight risk.
Well, I don't think he has really anywhere to go or any other motivating people or places that he would go to, especially given the fact that he's always loved his kids after divorce. They had a 50% custody arrangement. So working through these processes in the legal system and being close to family, like his mother and siblings who are in Southeast Michigan, he wouldn't have anywhere to go besides probably Southeast Michigan. And if the court wanted a passport, if he has one, surrender that. And again, I think a house arrest would be significant, especially at these early stages, for the court to be confident in his appearance and in safety.
Right, I probably should deny the defendant's bond. I'm not going to do that at this point in time. I'll let it certainly proceed to preliminary examination if the people wish to raise that at additional time, and certainly the court would consider that. But I certainly am not at this point going to reduce the defendant's bond. The defendant's bond motion for bond reduction is denied. Bond will continue as it's set. Thank you.
Thank you, Your Honor. And on the PCC part of this, we're asking for an adjournment. There's still some discovery we're waiting on, so can we have a date in 2 weeks?
Probable cause conference, April 3rd, 2025, 9 a.m.
Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Marquesi Hankey.
Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, P713.
All right, it's your motion.
I did file a motion to take the previous PCC hearing. My client's bond vote from privileges from the jail suspended due to allegations that he cut off his tether and contact with the complainant. Following that particular bond hearing, I instructed my client to not contact the complainant with period in the jail. I also instructed my client that if allowed to be back on bond, we would ask the court to hopefully just reinstate his original bond tether. I would note, Judge, that he has no prior criminal, well, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts. Obviously, people address this. Some of the language that was used during conversations, I don't have phone conversations myself, but I will admit, Judge, that it seems that my client had contacted the complainant even after his bond. And so I say this, Judge, again, I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah. He is.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something it means. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier bond that he was able to post to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So Judge, I am asking the court to reinstate his bond. And if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he's never had any contact with his family, his children. He hasn't been able to contact his dad, caretaker for. And so at the very least, the restriction on his phone privileges to contact family.
All right, Bill, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
My understanding, Judge, I thought community corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, you know, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on our motion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world's stopping me from you. I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continually, flagrantly calling the victim on other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but yeah, it's close, but I did pretty good. I said it okay right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. It's praised by myself. I can't say that I'm not in here for nothing. You know, obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. Again, please show mercy. Please. That's all that matters.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, the PCC.
Yes, sir. Is all discovery complete?
It is. And I would ask, if possible, what if possible.
Witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge Perry.
And Your Honor, I did want to make the court aware, I did contact the jail yesterday and they have blocked full of victims, new numbers and old numbers, so there should not be any
More calls coming through. All right. Thank you.
Thank you very much.
Thank you, Your Honor.
I said messed. I did. I did. I thought I did pretty good. I thought I did. I paused. I said messed. And then went on. See? Aren't you proud of me?
I'm proud every day.
You know, a little bit more sincerity in that. That'd be good.